Hello everyone. In the previous clips, I already provided you with the first two parts of this chapter, including the study of legal reasoning and the art of legal reasoning. Now, I will focus on effective legal writing style. I'm sure that every one of you already have certain experience regarding reading papers in legal context, maybe commentaries or maybe textbooks, right? So now I would like you to clarify what criteria to make a piece of writing to become effective, especially in the legal context. Well, I assume that I will receive different answers from you, viewing from different angles. However, there are certain agreements on criteria for effective legal writing. In the following slide, I will show you these criteria and discuss about them. Criteria on effective legal writing. They include clarity and vividness, conciseness, forcefulness, punctuations, and other rules of grammar. Of course, punctuation and other rules of grammar are a must because it is basic, right? It must be in order to have a fluent and effective piece of legal writing. I will focus in more details about the first 3 points. First of all, and vividness. What does it mean by clarity and vividness? In order to have a good piece of writing in legal context, first of all, the meaning of your paper must be clear, must be exact. Therefore, you need to find the right word to describe your ideas, to transfer your thoughts. Now, when you choose the right words, it needs to be straightforward and avoid the words that blur meaning. I can show you an example. A person describes the murder, and in criminal case, it is very important to know the criminal conduct. And if you read the paper saying that a wife was killed by her husband, she was injured very seriously and lost blood, therefore she died. Yeah, if you read such a paper, can you know what happened exactly? What was criminal conduct in this case? No, you don't know what tools and how the husband killed his wife. You didn't know what time, when it happened, and was there any light? Was it in the room or was it in the restaurant? Was the woman straight back against him or something else? So therefore, it seems to be short, but it is not clear enough. It is not the straightforward into criminal conduct. And therefore, in terms of clarity and vividness, you should write down your ideas precisely. It means that exact and careful words that you have to choose, and you avoid insecurity in convoluted constructions. I can give you some example, but first of all, I would like to make it clear that you should figure out exactly what should be said and then say it precisely. Reduce the fear. Try to hide your fear with a lot of words but without meaning, or it's just running around. The insecure writer who is not sure what to say may try to hide that insecurity in convoluted constructions. Example. Here I can give you an example of insecurity in writing. The background is that the K was heard for the first instance, but the defendant was not happy with the judgment. Therefore, he wants to appeal, and the applications for appeal started as follows. The above caption appeal is maintained by the defendant as a direct result of, and then some of the reasons. And you see, this is quite a long phrase with a lot of words. But what does it mean? It just simply means the defendant appeals because, and then the reasons. So between the first version and the second version, what would you prefer to read? And what would you prefer to write? I would recommend the second version. It is go directly, straightforward. So this is a kind of clarity and vividness. You need to understand the importance of clarity and vividness in law. In order to see it, you have to consider two things. You must prove everything you say, and you must limit the content to be direct and straightforward, because no matter how important the issue is, your reader will be able to spare only a limited amount of time to ponder what you write. Okay? I come to the second criteria to have an effective legal writing. This is conciseness. What does it mean by conciseness? Conciseness, and why it is important in legal writing. It is very important because by nature, concise writing is clear and short. And you see, you might be mixed up with the criteria of clarity and vividness. But clarity and vividness includes inside the exactness, and not only short and you just omit or delete out all of the details, but clarity and vividness requires as well preciseness. But conciseness is in nature, it must be clear. The typical readers of legal reasoning have no time to spare, and they either resent inflated verbiage or will simply refuse to read it. criteria, conciseness, clarity, and vividness are closely related, right? So now I would like to give you an example. But before giving you a detail, so now I give you an example. But before showing two different versions of the same idea, I would like to give you some background so that you can easily understand. The seller and the buyer agrees to make transactions. The object of these transactions is the cow, female cow. Both believe that the cow is not pregnant, but later on they discovered that the cow is pregnant. So the questions raised is whether the price in the transactions should be increased, right? That is the brief information about the background. So now you read the information here. It is important to note that, the lawyer said, you see, this is the gray version, and later on I give you another version that is the yellow one. It is important to note that at the time when the parties entered into the agreement of purchase and sale, neither of them had knowledge of the cow's pregnant conditions. This is a quite long sentence, isn't it? Is it easy to understand? Is it a good and effectively writing piece of sentence, right? No. And it can be rewritten as follows. When the parties agreed to the sale, neither knew the cow was pregnant. What could you prefer to read? And what could you prefer to write? Me, myself, I could prefer the yellow version because it is clear, it is exact, right, and it is concise as well. So now is another sentence. Continue with the previous one. This is only one sentence, you see. And it is said, because of the fact that the cow, previous to the contract, had not become pregnant, despite planned and observed exposure to bones whose reproductive capacities has seemed demonstrated through past experience. The seller had made the assumption that the cow could not be able to produce offspring. Now make sure that first of all you can understand this sentence. And secondly, can you rewrite this sentence and make it much more straightforward and concise? Can you? And can you show us your example? Now I can show another example of rewriting of this sentence. It simply says, the seller had assumed that the cow was infertile because she had not become pregnant when the seller tried to breed her with non-stud bones. That is just the main ideas of the sentence. It's easier to read it, quicker to be understood, right? The next example. Continue. Due to the fact that the seller had made a statement to the buyer describing the cow's opportunities to reproduce and the failures thereof, there could have been, in the buyer's thinking, no purpose to any further investigation or inspection he might have considered making. So now, my request to you is that you should rewrite this sentence using the previous criteria we already discussed. And then, the second thing you need to do is that to analyze what techniques you have used in order to rewrite this sentence, in order to make it shorter, straightforward, and concise enough, right? Concise enough to transfer the information. I can show you the rewritten. Because the seller had told the buyer about the cow's history, the buyer did not investigate further. Now, what differences, what techniques have been used in order to rewrite the gray version, turn it into the yellow version? Can you find out? The last one. For these reasons, the contract did not include a provision for an upward modifications in the payments to be made by the buyer to the seller in the event that the cow should later prove to be capable of reproduction. The same questions. Can you rewrite this version? And what techniques did you use in order to rewrite it? I can give you an example of the rewritten sentence. Thus, you see, for these reasons, 3 words just coming to thus. The contract did not provide for an increase in the purchase price. You see, the contract did not include a provision for an upward modification in the payment. You see, upward modifications in the payments, it's kind of noun phrase. But here you see it's just provide an upward modifications. It means an increase in the purchase price. If the cow should turn out to be fertile, here the cow should later prove to be capable of reproductions. It's a long phrase, sentence that you can to be fertile. So replace the word, the sentence into some of the word that can express the same meaning, but it is concise and clear and short. So we turn back to the questions. How did the verbose, rough draft on the left become very nice, concise, and finished product on the right? What techniques have been exploited? First, some sentences were rewritten. Instead of using passive voice, the rewritten sentences use the active voice. A person or a thing did something. And you see, I pointed out to you that there are some very carefully chosen nouns and verbs. And many modifiers become unnecessary because the meaning already incorporated in nouns and verbs here is some of the reminding because you might miss it. The cow's pregnant condition, you see, just a noun phrase, it becomes the cow was pregnant. Despite planned and observed exposure to bulls whose reproductive capacity had been demonstrated through past experience. It's quite long, right? So we just put it, he tried to breed her with known stud bulls. Known, it means that the capacity have been experienced through the past, right? Already know. Despite, it's not necessary because it put into the context and you can understand. So now it's quite long. There could have been, in the buyer's thinking, no purpose to any further investigation or inspections he might have considered making. It's just using some of the noun phrases, but you try to describe who did what, who, someone or something did something. The buyer did not investigate further. Kind of techniques have been applied. The second techniques here, words and phrases were eliminated if they could not justify themselves. It is important to note that. Why it is importance? The word importance is communicated in the context already, so don't need to put it in here again. Previous to the contract is deleted because it's also communicated by the context. Third, each word and phrase was weighed, was evaluated to see if the same thing could be said but in a fewer words. At the time, simply when entered into the agreement of purchase and sale, it just simply say agreed to the sale. Neither of them, simply neither, had knowledge of, just knew, right? Parts here you see, especially you see here, they make a lot of noun phrase, made the assumptions, just assume. Right. Pointed out a lot of. Now the third criteria is forcefulness. What does it mean by forcefulness? Forceful. It means that you connect different ideas, right? You need to specify the relationships between one ideas with another, and you need to identify the ideas that are the most important or completing. It means those means forcefulness. The relationship between ideas can be made clear through transitional words and phrases and through demonstrative sentence structure. Transitional words, for example, first, second, and finally, for example, right? Here's the other examples. Accordingly, as a result, because, but consequently, or in spite of, in even that, not only but also. Various transitional words and that you can use. And you need to note that some transitional words and phrases are stronger than others. And if you want to emphasize the ideas, you need to select the proper transitional words. And also be careful to select those that accurately represent the relationships that you want to show. For example, that is the cause relationship, so you need to use because, or as a result of, or as a consequence. But if they do not, the two ideas do not have the causal relationship, so you need to point out the timing, for example, firstly, secondly, thirdly, for example, so that if all the ideas are equal and they all together prove for one preposition, so that you need to clarify them accurately. So some examples of the demonstrative sentence structure that you can use among the here is some subordinate sentence elements that showing affirmative relationships. And this is quite comprehensive ideas about the courtroom, so you can read here. The amended courtroom provides for such sanctions, which eliminates the need to rely on any inherent powers the court might or might not have to punish attorneys whose vexatious conduct multiplies the court's work. You see here is subordinate sentence and is showing affirmative relationships. This subordinate sentence showing affirmative relationships with the rules regarding sanctions on to punish attorneys, right? Some subordinate sentence, but they show the negative relationships. Here, for example, although the attorneys here argues that he made these notions only after a thorough review of this court's precedents, he has not been able to cite a single decision in support of his position. This is the story about the attorney who made a lot of application to the court to multiply the court's work. And the court just cite out the rules in the previous example. You see the rules that allow the court to punish such an attorney. And these are two examples relating to this case. Join the independent sentence elements to emphasize logical relationships. I already show you not only but, right? Here is an example. The conduct of this attorney is at least as egregious as that of other attorneys who have been so punished. Not only has he served and filed a frivolous pleading, but he has made several equally frivolous motions. That's it, summary. Forcefulness in legal writings is also to identify the ideas that are the most important or compelling. And you see there are several ways to do it. First, you can place an important idea at the beginning of a sentence, of a paragraph, or of a passage. Or a series of sentences can be arranged so that shortest and simplest of them conveys the emphasized idea. Here, This art needs serve and find a pleading alleging extremely unlikely facts without making any factual investigations and under circumstances indicating that his client's only motive for litigation was harassment. He made numerous frivolous motions, including one for preliminary injunctions, where his clients were in no way threatened with harm. He has now brought an appeal without any basis in statute or precedent, and he has submitted a record and proof not in compliance with the court's rules. So you see, the most important ideas were placed in the first sentence of this paragraph. And from here, from the second one, he made numerous frivolous motion, etc., are examples to prove for the first sentence ideas. The last criteria for legal effective writings are punctuations and other rules of grammar. Regarding this, you just need to read some of the papers here, for example, right? So these are 4 criteria of good or effective legal writing. So I hope that you can apply them into your piece of writing. After drafted your paper, you need to use these criteria to evaluate your own writing, whether they are effective or not. Okay, good luck.